Okay, welcome to your first substantive video in family law. So unlike the other two videos, this one is going to be the first video that shows you some of the concepts that we're working with this semester. And I'm going to cover the whole week of August 10th, but I'm going to split that into two sections. Typically, we would have 2 days of class, and our lecture today isn't going to be as long as a class period would be because we won't have the discussion. The discussion part will come in the discussion boards. But I'm going to get through in this video, if I'm looking at the syllabus, everything but the last two sections, so it's not evenly split. Post-nuptial agreements, paternity, 3 sections, and the putative father registry will be in the next little video. I'm going to split those in half, but that's for the entire week. So this whole section talks about things that fall short of or come before marriage. And I get that I've kind of split up the text because I want to organize it chronologically. And so we're starting before marriage or outside of marriage today, because your book talks about what a family is. And I don't know that that makes a huge difference, because everyone's definition of family is different, as you saw or will see when you look on page 3. When we talk about family law, what we're really talking about is domestic relations law. So it's more than just what your definition of family may be. It encompasses marriage and parenting, but those don't have to happen at the same time. It encompasses name changes and adoptions and divorce and all of those different things. So while we may call it family law, how you define family is ultimately up to you. And it's more about the concepts of marriage and child raising and parenting. So that's where I want to start this with. The definition of family is what your book starts with, but that's not necessarily, however you define it, isn't necessarily the be-all and end-all for what you're going to learn this semester. So as we go throughout this lecture today, I have my whiteboard here that I'm going to use with my markers, and I'll try to write large so you can see it. I'll also, I may not slow down my speech quite as much as I could, because you have the option to watch this again. And then what I'm going to do is I'm going to create a separate discussion board post on the Blackboard week where you can ask questions of this material. So if you have a question, normally in a face-to-face class you'd raise your hand, we'd answer it, we'd talk about it, we'd discuss all those good things. We can't do that this way. But if you have a question on this lecture, write it down, post it in that discussion. You don't have to do it, you don't have to read it, but what it does is it allows you to ask questions now as opposed to waiting for our Zoom meeting. And it allows everybody in the class to get the answer to your question if they so choose. It's another way that we can approximate a live lecture, and I like it because you can get those questions asked and answered quickly. So that will be on Blackboard later on today so that you have the opportunity to look at it. Okay, what I also want to start this discussion with is the understanding that your textbook does not tell you that we have some fundamental rights that when you take constitutional law you'll learn about. Some of these fundamental rights are explicit in the Constitution, but some of them have been implied. And some of these fundamental rights, like privacy, you're not going to find the right to privacy in the Constitution, but it is well established throughout the penumbra of emanations, the umbrella term that we use to talk about all these different amendments and constitutional provisions that give us privacy. Some of the ones that affect us in this discussion are the fundamental right to marriage and the fundamental right to raise your children. You're not going to see Amendment 47 with the right to marriage, but those fundamental constitutional rights are ones that were almost taken for granted, and they've been interpreted to be part of the Constitution. So we have that fundamental right to marriage. That's not to say, like our express Second Amendment right to own and use firearms, it's not to say that it can't be restricted or legislated or changed or modified in some way. But we are starting from that principle, that we have these fundamental rights of marriage and parenting. But what page 3 is telling you, which is where our text starts today, is that marriage is less and less popular over time. And that's what your discussion board this week is about, is that for whatever reason, well, for a lot of reasons that hopefully you'll expound upon in that board. People are less likely to get married today than ever before. And what I want you to start thinking about, we're going to talk about the black letter law for purposes of the bar, but I also want you to think as to how the law might change in the future and whether or not it should, because as lawyers, you are where that happens. Yeah, a lot of you are going to be getting individual divorces for clients or working in criminal law somewhere and helping individuals. But on a macro level, we need to think about how, and we should enjoy thinking about how things might change in the future. And some of the reasons that marriage law and family law is changing is because it is dependent upon other areas of our law. We're not going to read Obergefell. And we're not going to specifically read it. We talked about it in the discussion board. We're going to talk about it today because it's at its heart, a very simple case that many of you are familiar with. It is the constitutional gay marriage case. I use it in all of my classes to discuss constitutional changes and lots of other issues outside of the narrow focus of the actual case. But because of Obergefell, there are all kinds of ripples that we may see coming as changes in the family law system. In addition, keep in mind that the cases and the pieces of law that we look at in this class do not stand alone. Family law goes hand in hand with a lot of other subjects. When we look at some of the cases from this particular lecture, we see wills, trusts, and estate law coming in. We'll see contract law coming in today. We'll see criminal law and administrative law coming in towards the end of this semester. It's one of the things I really like about it because if you know some of those other areas of law, it makes learning it easier, and it also makes it make a little bit more sense because when you can put things together sort of at the end of law school, when you take the bar, when you start practicing, it makes it make sense. And so keep in mind that that's where the focus of these little videos, these little lectures are going to be. So the focus on number 3, page 3, is we see less and less marriage. Why? Marriage is a civil contract. We'll talk about that for next week in more detail. But you may believe that marriage is about love and family and making connections and having a lifelong commitment to someone, and you may believe that it is faith-based and that there are, in your particular faith, there are certain responsibilities or certain things you should do before you get married, when you get married. That is all well and good. But what we're talking about legally is the civil contract to care for each other. I'm not going to get into detail with that now because that's really for next week. But everything we talk about today is either going to predate that civil contract or be outside of the civil contract. So cohabitation, civil unions before we had the constitutional right to gay marriage, and prenuptial agreements. All right, so starting with our first case, and there's a little things in your text about that you can choose to read after page 3 about the pros and cons of whether we should keep marriage around, whether we don't need it anymore, that you can look at if you choose to prepare for your discussion board post. But for the most part, I'm going to talk about the cases in the textbook. I've talked briefly about Obergefell, which was not on your reading list, but it's a fairly simple case that you're all familiar with. I'm going to start with Blumenthal versus Brewer on page 16 of your text. The site is 69 Northeast 2nd, 834, for those of you who are still waiting on your text. All right. The Blumenthal case is an interesting case because it is a judge suing a doctor, same-sex relationship, not a marriage, in 2016. So in 2016, could they have gotten married if they chose? Yes, for a couple of reasons. Obergefell was 2015, so they had the constitutional right to it. And then previously, if you read Blumenthal, or when you read Blumenthal, you'll see that Illinois law, which is where this case comes from, not only had civil unions for several years before 2016, but as of 2014, they had made marriage between two people of the same gender legal in the state of Illinois. So Dr. Blumenthal and Judge Brewer could have chosen to get married. They didn't. So now that we have Obergefell, where we have this vast section of people who could not get married previously in half the country, more than half the country, now they can. Does that mean marriage should stay marriage and everything else should stay everything else? That's really the concept of Blumenthal. So when we get to next week, ask yourself, what does marriage give you? What do you get from it? Should we have it? Should we keep it? We'll talk about all of that. So Blumenthal versus Brewer, long-term relationship between a judge and a doctor. And they are seeking, the first thing that they're seeking, they've separated, right? They're not going to live together anymore. But they've had a relationship that approximated a marriage, but they never signed on the dotted line. If you've heard the phrase before, if it didn't happen on paper, it didn't happen, that's this case. And that's fairly typical, that there are, you may have in your head, you may have heard about common law marriage and palimony and a lot of things that gave people marriage-like rights. After Obergefell, much of that, if it hasn't already gone by the wayside, will, because much of that was done to protect people in same-sex relationships, to give them some sort of equal footing with marriage. We don't need that anymore. In addition, a lot of those palimony or the common law marriage or the things that are short of marriage, they needed to protect women who were in these marriages, not these non-marriages, these situations that fell short of marriage. And do we need to do that anymore? Typically, I'll tell you a little bit about history too sometimes as we go through this. Typically, historically, if a woman did not get married, what did she lose? She lost property rights. She lost the ability to care for herself because typically, historically, women either didn't work outside the house or worked less or part-time outside the house. And so perhaps, legally speaking, specifically women needed some legal protection shy of marriage. We may not need that to the same extent anymore. We'll talk about a case later on in this lecture that specifically talks about gender and how things have changed. But that's how some of this is changing. Okay, so Blumenthal versus Brewer, long-term non-marriage. And when they separate, they are seeking petition of the home. That means that the home was, both of their names are on it. This is not a situation where when they're splitting up, they're trying to separate the house because they believe it to be a marital asset. They were not married. They were petitioning the home because they no longer wanted to own it together. So same action, whether they are business partners, brother and sister, it doesn't matter. In the context of that petition, that, hey, let's get our names off this house and split it up because we agree we've both financially contributed and we own it jointly. In the context of this, the judge says, but I also want half of your gynecological practice, because the doctor is a gynecologist, and the judge is asking in the petition lawsuit for marital common law remedies. We're splitting the house. Let's split up your practice. Was the judge's name on the gynecology practice? No. So the only way she can get her remedies is to get a marriage-like remedy from the court. Okay. So this, again, will dovetail some contract principles into family law. The reason that the petition, in this particular case, the petition of the house, the splitting up of the house, was okay was because both of their names were on it. They jointly owned it. That's not a family law issue. That's a contract issue. So then the judge comes in and says, well, we need a marriage-like solution for the rest of our assets. The time and energy I put into the practice of my partner, I want to get some of that back. The problem is that they didn't treat that investment as a contract, and so they couldn't get contractual, the judge couldn't get a contractual remedy out of it. So the judge sought marriage remedies. Even though we weren't married, we did some things that approximated marriage. We had a joint account. We paid for things for the practice out of that account. We lived together for a number of years. We should have marriage remedies. And the court in Illinois said no. This is going to be standard across the country, especially post Obergefell. In this case, the court said, well, we've looked at some precedent and we didn't extend that previously. And not only that, but if the judge, she is a judge, we're not going to forget that, wanted marital remedies, there are all kinds of legal ways that they could have put that stamp of approval on their relationship. They could have gotten married as early as, I think, 2011 in this state. They could have had a civil union, which predated that. They could have put her name on the practice. They didn't do any of that. And so the court in this case said, unmarried cohabitants, we are not going to extend marital property rights to. We're not going to do that. Fair or unfair? If you think about it, are there reasons, financial reasons? Because if marriage is a civil contract to commingle our assets, take care of each other jointly, are there reasons why you would not want that? Now that since 2015, everybody, whether you're marrying someone of the same gender or someone of the opposite gender, everyone has the entitlement to marriage now. Should we keep it that cohabiting is something different? Is there a benefit to that? That's just something to think about. What you should get out of Blumenthal versus Brewer is that now there's no distinction between marital property rights in the LGBTQ community, and that's also out of Obergefell. That we also, what is not explicit in this case but should be in your mind, is that there is a presumption against common law marriage now. And now I'm going to actually use this. So the three things. One, marriage is marriage whether or not we are talking about two people of the same gender or two people of the opposite gender getting married, for property purposes, for every purpose. But now that we have the constitutional right to it, many of those other remedies that were historically in laws across the country are now not needed. We don't need to protect people in relationships that approximate marriage because now everyone can get one. Two, I see that you can't see this very well, so I'm going to change colors and write bigger. Modern American law has less of an emphasis on common law marriage. One of the things that you may have heard a non-lawyer say, there's lots of them, oh, we're just common law married. Well, we've been living together so long, we're common law. It's common law. No, it's not. Common law marriage historically, which we'll get to in a second, had some things you had to prove. It wasn't just, oh, you live in the same place long enough and you're automatically common law married. No. Even that being said, the states that recognize common law marriage are smaller and smaller and smaller. I will update you. Another thing that I'm going to do after finishing this lecture is to update you with some statutes. And those statutes are going to be based on the states that you said you'd be practicing in. So most of you are going to be practicing in Kentucky. I think there was a Colorado, there was a New York. There are a couple of different states that I'll try to update you as well. But by and large, common law marriage isn't a thing. It is not, certainly not widespread, and it is certainly not, we've been together so long, we're common law. No, that is not the case. And specifically, also because of Obergefell, that's less and less likely to be the case because now everyone can get married, mostly. There are certain families that aren't legally recognized by the state, like polygamous marriages and things like that, but less and less emphasis on common law. And the biggest thing from Blumenthal versus Brewer, well, going back to this one. Is that if you don't have a marriage, you don't have marital rights, specifically marital property rights. So, what could the judge have done? They could have gotten married. If they wanted to, if she wanted to protect her interest in the medical practice so badly, she could have gotten married. Could have had a civil union. Could have put her name. Could have drafted a contract. Could have had an agreement, a deed put in place for her investment in that practice. But that's not what happened. So the court's not going to extend her marriage rights in that instance. And the court looked at precedent and looked at the fact that there have been these other remedies in statute, the civil union remedies. The court said if the legislature wanted to extend marital-like remedies to property of unmarried cohabitants, they could have. They didn't. Okay. I'm gonna stop this video and let you write down questions, take notes. Maybe we'll do it in little pieces, but I need a better dry erase marker and a better eraser, and I will be back in a second.